concern.
I will only trouble the court on two more points.
Say that again.
I will only trouble the court in respect of two other matters which I wish to draw to its attention.
Well, you're not troubling us at all, Mr.
The first is that the Industrial Court Act must be looked at in conjunction with the Antigua and Barbuda Labour Code, because it has specific jurisdiction in respect of dealing with employment matters and trade disputes. Now, if we look at Section 8.1, which my learned friend referred to earlier, and it's at page 205 of the record. Subsection 1. The court, as respects the attendance and examination of witnesses, the production and inspection of documents, the enforcement of its orders, and other matters necessary or proper for the due exercise of its jurisdiction, shall have all such powers, rights, and privileges as vested in the High Court on the occasion of an action. I respectfully submit that the words "on the occasion of an action" creates a limitation in respect of those powers, rights, and privileges vested in the High Court which can be exercised by the Industrial Court. So we look at Section 7.1, which deals with the jurisdiction. And of course, A, to hear and determine trade disputes referred to under the Act. B, to enjoin a trade union or other organizations of employees or other persons or an employer from taking or continuing industrial action. And C, to hear and determine any complaints brought in accordance with this Act. Specific in terms of those three areas. And then we look at Section 10, which is on page 207. The court may, in relation to any matter before it, make an order or award relating to any or all of the matters in dispute, or give a direction in pursuance of the hearing or determination. And I would respectfully submit that our claim, or our submission, respectfully, that the Cabinet is not the employer. Before the Industrial Court, the orders which can be given would be in respect of the Board of Education and its relationship with the employer, with the respondent, not the Cabinet Minister, who is an appellant in this matter. It's necessary that we go to the High Court for the declaration that we seek. Second point I wish to make, I draw the court's attention to the findings of the Court of Appeal, which appear on page 129 and 130 of the record. Here the Court of Appeal holds, or has held, on the one, at page 90, under CPR 2000, applications for declarations are regarded as a distinct category from applications for judicial review, even though they are both applications for administrative orders. And if we go to the last sentence, on the one, the rules do not stipulate that a claimant who wishes to obtain a declaration must first obtain the leave of the court. If the rulemakers wished to require a claimant who seeks an administrative order in the nature of a declaration to first obtain the leave of the court, they would have said so clearly. I commend that finding to this court. Then we look at 2. In our jurisdiction, a court must look to CPR 2000 to ascertain the procedure a claimant must follow in order to obtain a declaration, and not the English civil procedure rules, which are not in pari materia with CPR 2000 insofar as administrative orders are concerned. And I had made the point earlier that in respect of declarations, under the UK rules of procedure, there are situations where you shall apply for a declaration, and there are situations where you may, by way of judicial review. We have no such qualifications at all in respect of ours. And the third finding, an applicant who seeks judicial review can also seek declarations in such an application. However, there is nothing to prevent claimant from simply filing an application for a declaration coupled with a claim for damages. Such an application would be consistent with a claim under CPR 2000 for an administrative order. And I draw the court's attention to part 56.1, sub 4, which appears on page 479 of the record. The rule reads that in addition to or instead of an administrative order, and seeking a declaration is such an order, the court may, without requiring the issue of any further proceedings, grant A, an injunction, B, an order for the return of any property, real or personal, or C, restitution or damages. So there's nothing intrinsically wrong in seeking a declaration to ask for damages. That is allowed under sub 4 of 56.1. And we have so done. And of course, the damages that we seek are damages in respect of the reputation of the respondent, which we claim suffered as a result of the actions of the minister. We will not be able to go to the industrial court in respect of that claim.
That's not because, presumably, the industrial court can't award damages for damage to reputation, but because they can only do it against the employer.
Indeed.
Yes.
Indeed, may it please the court. Finally, I just commend the my submissions, or the respondent submissions filed on behalf of the respondent, which appear from page 49 to page 59 of the record.
Paragraph?
From page 49.
Yes, I'm working from different copies. Yes. I'm working from different copies, so the paragraph?
Look at...
Don't worry, I'll go to page...
Yes, from 1 to 49. It's 49 or 30? Yeah, 1 to 30. Yes. 30. And the full chronology of events...
Yes, which paragraph are you referring to?
No, I was referring to the whole of the submissions.
I see, sorry.
But yes, under paragraph 4, we deal with the private public law point. And then we do deal with the jurisdiction of the Supreme Court here in England vis-à-vis our Antiguan provisions under that private public law point from paragraphs 4 to paragraph 12, particularly, or specifically. And the full chronology of events prior to the legal action, which I submitted to the court during the housekeeping process. I commend to the court because that would give the court the correct chronology in respect of what has happened in respect of the respondent by the minister prior to the respondent accepting that the board had constructively dismissed her. And on that basis, the action was taken. Unless there are any questions that the court may have.
You referred a moment ago to the third holding of the Court of Appeal in this case. Just trying to understand it. I think you referred to it in conjunction with the provision about claims for injunctions and damages or return of property in addition to or instead of an administrative order. But actually, if you look at the basis in the judgment of the third holding, it's really paragraph 71, or perhaps 70 and 71, on page 153 and 154. And 70 says there's nothing to prevent an applicant from simply filing an application for a declaration coupled with a claim for damages. That would be consistent with CPR 2000.
Indeed.
It's trite that a claim for a declaration alone can be pursued. That seems to be saying that the two heads are entirely disjunctive, and if you happen to claim a declaration plus damages, that's all right. And then over the page it says the conjoint effect of 56.1.1 and 56.1.2 shows that there are four types of administrative applications. And then it says, in any event, if an applicant files an application for judicial review seeking an administrative order for declarations of damages, the learned judge has plenitude of power under CPR 2000. And then it refers actually not to the rule you referred to, it refers to a later rule which it numbers incorrectly. It should be 56.10.2c, which is the one which says that you can substitute in another form of
relief.
Of application. Where there's an administrative order in front of you, you can add or substitute a claim for other relief or substitute another form of application. So it has to be a proper administrative law claim.
Indeed.
What I don't understand is just going back to the sentence in the text. It says, if an applicant files an application for JR seeking an administrative order for declarations and damages, which was the state of affairs that existed in the court below. Why was it? I thought, is the court here assuming that your client's claim was a claim for application for a judicial review?
No, it's not.
No.
In fact, it was the other side that was suggesting.
No. I see. So if it happened you filed it as a claim for judicial review, the learned judge could correct the position effectively.
Indeed.
Yes, I see. And then he goes on, I'm of the considered view these applications ought not to be considered of a nullity because of such an irregularity. What's the irregularity on his view? Insofar as the trial judge has the jurisdiction to treat a JR claim as an administrative claim. What's the irregularity?
I see the point that is being made here. I would think, because it was not an irregularity that is actually part of the respondent's case, I would think that it was just a general statement that is being made that if there is an irregularity in respect of a particular matter, that the court does have the power to grant an alternative.
But it does
remedy.
rather look, the phrase, which was the state that existed in the court below, as if it's talking about this case.
Yes, it does.
Is there anything in the argument that leads the court to take that view, that this existed in the court
There is
below?
none, because always simply, our application before the court below was simply declaration and damages.
I've seen that, but is there anything in the argument
In the
that was
arguments.
advanced to the Court of Appeal that led them to say this?
Not to my knowledge.
No, 74.
My learned junior is referring to the paragraph 44 of the Court of Appeal judgment or the trial judge? The Court of Appeal judgment, because
Of which?
I had to amend, we did amend our,
Paragraph 44 of where?
of the Court of Appeal judgment.
Of Scorpio, yes, right.
Yes, at page 147, as the affidavit amendment. Because there was a certain amount of certain irregularity in respect of our affidavit. And in fact, we filed an amended affidavit.
Well, I don't think they're talking about that. It's all, paragraph 71 is a bit of a puzzle, since paragraph 74, the court clearly goes on to say the fixed date claim was merely seeking declarations of damages, was not, therefore, one for judicial review. So anyway,
Yes, and it concludes by saying, accordingly, the learned trial judge was correct in refusing the application to strike out on the basis that leave was not obtained.
yeah. You see,
So,
paragraph 69, they've rejected your argument that judicial review is limited to the three prerogative writs, and they do that because of the word includes. Anyway, I'm finding the reasoning a bit opaque.
kind of odd.
Yes.
But that notwithstanding, I think we're standing on good ground when we say that this is not a case for judicial review and therefore leave is not required.
It's a public law claim, you say, which is within the declaration's head. Yes. Are there any points? No further points? Thank you
Okay, please
very
support.
much, Mr. Simon. Yes, Ms. Artisi,
My Lord, yes.
are there any points you wish to add to your...
My Lord, yes, if I may.
Yes, of course.
My Lord, the position is quite, in my submission, straightforward. My Lord Reid put his finger on it, and it's accepted by my learned friend on behalf of the appellant, that the respondent is an office holder of a statutory office, exercising a statutory function. And that falls clearly within the Ridge guidelines of cases. And in my submission, Ms. Isaacs falls within that third category of cases identified by Lord Reid in Ridge, that she's an office holder who's entitled to know what the allegations are that's been made against her on dismissal and an opportunity to be heard. My learned friend on behalf of the appellant accepts this proposition, but he goes on to say there's a caveat to it, as my note indicated, and his caveat is not if there's an alternative remedy. My learned friend and my Lady Black raised the question of whether there was in fact an alternative remedy in the industrial court, and the court has been taken to the various statutory Acts, the Industrial Court Act and the Labour Code. And may I say the two must be read together. And when taken together, it's quite clear in my submission that the Industrial Court, its function is solely to adjudicate on matters going to wages, conditions of work, health and safety, and so forth in the context of an employer-employee relationship. To some extent, this House have dealt with this question before, about if one is satisfied that the respondent falls within a public law arena to bring a claim under 56.1. The next question is the procedure that she brought herself within on the 56.1 for a declaration is one which she could properly use. And I'm conscious of my Lord Mance's comments in relation to where does the line fall on this. In the case of Dumas, which should be found on page 212 of your bundle of documents, and the citation for that is 217, One Weekly Law Reports, page 1978. Dumas is a case of the Attorney General of Trinidad and Tobago. Briefly, going back to that question of a public-spirited citizen, Mr. Dumas was seeking various interpretations of the provision in a constitution relating to appointments of two particular individuals to the Police Service Commission, and he commenced the claim by a fixed date claim form, and there was a constitutional element to it. But most significantly, in my submission, at page 1987 of the report, which should be page 221 of the bundle, at C, Lord Kerr giving a judgment at paragraph 25 deals with, there's a distinction, of course, and my little friend, the appellant, is not relying on McMahon, but McMahon was distinguished in the context that the Constitution would necessarily trump that position, the Constitution of Trinidad and Tobago, that is. And the other distinguishing feature is that Trinidad and Tobago had a Judicial Review 2000 Act, which more or less put judicial review on a statutory footing, as it does in the UK, under Section 31 of our 1981 Act. But I wish to rely on its C, the sentence starting fourthly, the fourth reason given by Lord Kerr in allowing Mr. Dumas to proceed with his application on, in this context, on the 56.1. And 56.1 of the Trinidad CPR, para 11, is effectively the same terms as the Antigua and Barbuda, the 56.1. And what he says there is provides for declarations against public bodies, and it's accepted by the appellants and for this court today that for the purposes of the respondent's application, cabinet and minister would come on the public body. But what's important in the word is Lord Kerr says against public bodies as well, so a declaration is one that can be obtained, as well as an application for judicial review. So that's the second thing that can be obtained. And claims under the Constitution. And indeed, when one turns to CPR 56.1, which Lord Mans had made a point earlier, it's clear and unambiguous language in my submission. There is no need to strain the law to seek to interpret what is set out at 56.1.
Why haven't we been given Belize Bank and Association of Concerned Belizeans, which seem to be very much in point, referred to in
Yes.
the Dumas case?
Yes.
We ought to get that. Can you, between you,
Yes.
make it available?
Yes.
It says it's unreported.
Trying to adopt the reasoning in yes.
Well, obviously you need to see it in context, but
Yes.
it does look pretty
Yes.
relevant
Yes.
for the appeal.
My Lord, yes.
We
Belize.
need also, if possible, to see the relevant rule in Belize, if indeed it's not spelt out fully in the judgment.
And so, my Lord, could you repeat what you...
Yes. It's said to be a similar procedural rule in Belize, so we would be assisted, I think, by seeing that, if and so far it's not fully spelt out in the judgment.
I'm thinking about the concern here is essentially that the concern on the part of the appellants is that there is a requirement for leave for judicial review, and it shouldn't be possible for that requirement to be obviated by presenting what is in reality the same point in a different guise. I'm just wondering about that. I noticed we have an explanation of why there is a leave requirement in relation to the remedies in public law in England at page 120 in the judgment of the High Court in the present case, where Lord Diplock is quoted, what he said in the Fleet Street Casuals case, and he explains the reason for requiring leave, which applied, as he said, previously to in English law, previously to applications for prerogative orders, though not to civil actions for injunctions or declarations. His purpose is to prevent the time of a court being wasted by busybodies with misguided or trivial complaints of administrative error, and to remove the uncertainty in which public officers and authorities might be left. So he's really talking about problems that can arise from the generous rules in relation to standing, that the possibility exists of a busybody bringing an application, and of uncertainty if there's undue delay in bringing a challenge. Now, if one thinks about that rationale in the context of the rules that we're dealing with, the only relaxation of ordinary standing rules is in relation to applications for judicial review.
Yes.
In 56(2). So if you want a declaration or an injunction, you can't benefit from the sufficient interest test in 56(2). You would have to show that you have a personal concern in the matter which would justify the grant of a remedy, of a declaration or injunction or damages activities on ordinary principles. Which means that insofar as the leave requirement is linked to generous standing rules, it makes sense that the leave requirement is restricted to judicial review proceedings under the CPR. And I suppose the other matter is delay, the risk of uncertainty if claims aren't brought promptly. And that, again, is dealt with specifically in the CPR in Rule 56(5).
Yes, delay.
Which I think is dealing with any application for administrative order and not only judicial review applications. So if one thinks about what Lord Diplock was saying and translates it into the context of the CPR, it rather looks as though the only matter that he mentioned, which would be relevant to declarations, would be the delay issue, which is addressed by Rule 56.5. So perhaps it suggests that there is a coherent approach here.
Yes.
In restricting the leave requirement. Yes, but the leave requirement must be linked to the wide approach taken to standing for judicial review specifically.
Yes,
yeah.
And not for the declaration.
Yes.
Yes.
Yeah.
Well, the Belize case appears to be, is on the internet. I've got it, and was argued by Mr. Nigel Plemming, QC, and all the points which we've just been discussing, including the point my Lord's just been putting, are raised, including the submission by the other side that it would be very surprising indeed if the Rules Committee intended the judicial review protections to be so readily avoided, and so on. So
yeah.
it's all, this seems to be absolutely in point, and we'll have to invite you on both sides to make submissions in writing after this hearing is over on this authority. And it actually sets out the equivalent 56, which appears to be in fairly similar form, although slightly different order, funny enough, because it says this part deals with applications A for judicial review, B for relief under the Constitution, C for a declaration in which a party is the Crown, a court, a tribunal, or any other public body, and D, where the court has power, etc., which is the equivalent of RD. Yeah. So it is the same rule, effectively. In this part, such applications are referred to generally as applications for an administrative order, and so on.
It's well-trodden territory.
Yes, it's well-trodden territory, this. Well, it's pretty...
Yes. Most grateful to my lord.
And it points out the differences in standing and so on, which my lord has identified.
The case of Equal Opportunities Commission was referred to, another case decided by this House. It's to be found at page 350 of the bundle. And it's the reference is 1994 one appeals cases. It starts page 1. That case, in my submission, does not assist the appellant's case on the alternative remedy point, because, as your lordships have identified, indeed, my Lord Lloyd Jones raised the question that both matters in an ideal world could be heard in a single court if that single court had the competent jurisdiction to deal with both. In the United Kingdom, the regime is different, and the Equalities Act now has provision for jurisdiction of the employment tribunals. In fact, there's a section 124 that can actually, which affords the tribunal to grant a declaration, and that's not in similar terms in the Industrial Court Act in Antigua and Barbuda. But what's interesting about the Equal Opportunities case, and it may be this is something for the written submissions, but Lord Brown Wilkinson, starting at page 34 of the report, which is page 383 of the bundle, starting at F, he traces, which I believe my Lord Kerr was referring to earlier, the genesis of the judicial review procedure and history, starting with the before 1974 point and moving on.
Sorry, that was 3-1...
It's page 34 of the report, but 383 of
383, yeah. Right. Yeah, thank you.
And prior to judicial review being put on a statutory footing in this country, you had two routes of relief in public law. So you had the prerogative orders in the Queen's Bench, and then always, which is the bit we're concerned with, the civil action in the High Court for a declaration. But that was governed by an Order 15. Enters the 1981 Supreme Court Act, and judicial review was then put on a statutory footing in the UK. I think the point I wish to make here is that did not occur in Antigua and Barbuda. So to some extent, the position in Antigua and Barbuda can be viewed through the lens of a pre-1981 position, or even 77 position. And all we're left with is CPR 56 in a vacuum, because you have no Judicial Review Act, as you do in Trinidad and Tobago, or the 1981 Act here. And yes, it must be for Parliament in Antigua to amend the legislation or amend the rules, but so far as the courts are interpreting what the position is, in my submission, it's what is in 56.
These rules They are the CPR, though, for the East Caribbean Court.
No, this is Antigua, the 50.
Oh, this
yes,
is
Eastern Caribbean. That's right, Eastern
Eastern
Caribbean.
Caribbean. So it's not confined to Antigua and Barbuda.
Yes, yes.
So actually, to amend it, you would have to
Yes, exactly.
get.
Forgive me, yes.
What is the mechanism? That has to be done by international agreement, does it?
I have no idea. Maybe my
I may be of some assistance.
attorney.
It's one court,
Yes,
the Supreme Court of the Eastern Caribbean.
But it presumably doesn't control its own rules, does it? Or
No, it is allowed to. What would happen is that the judges would form a committee
I see.
and recommend rules which would then be adopted.
I see.
And that would be done in respect of each of the island jurisdictions. And it happens from time to time.
So there isn't a standing committee?
Yes, there is a standing
There is.
committee of the court.
Thank you.
Thankfully, Parliament does not interfere.
No. Right.
Well, that's the only point I make in relation.
No, that's very, thank you very much indeed.
Insofar as cases such as Sharma were relied on,
I don't think they were they? But I don't recall a reference to Sharma and Antigua.
it's only in the written documents. I believe.
Well, if it,
It's in the written.
well, then you better deal with it because technically it's in front of us. But is there some point on it? It seems rather a long way.
No, that is the point I'm about to make. It's the Chief Justice who was, because the Court of Justice, very delicate situation in this court, and the court effectively declined in a very sensible way not to interfere in some way or form.
Well, it was criminal proceedings. It was a criminal charge against him.
Yes,
And
he wanted an injunction.
if they want to challenge it, they do it in the criminal proceedings.
Yeah, exactly. So it seems to me that doesn't assist the court in terms of the facts and context of that case. The case of Harrison, which was referred to in the appellant submission, similarly, that's a case in which, prior to that case, there seemed to have been the position wasn't entirely clear as to the remit of the industrial court in terms of cases for unfair dismissal, because in terms of Antigua and Barbuda, because Antigua and Barbuda's labor code had a part 5 dealing with unfair dismissal specifically, which in effect said you'd had to go to a labor commissioner and there could be a review hearing and so forth and so forth. And so it wasn't clear whether that statutory process had to sort of take its course in the context of unfair dismissal, or whether aggrieved employees could, or employers could, go to the industrial court. And the judgment of Byron in that...
Sir Dennis Byron.
Yes, Sir Dennis Byron. Known as, I think he was J-acting then. Was he effectively gave a judgment saying, no, you can go to the industrial court. So that doesn't assist in this case, is the point I'm about to make. My Lords, final point on the respondent's reliance on Shoesmith. The point being made about Shoesmith, as my Lords, my Lady would be aware, was, although it's a Court of Appeal decision, it appears at 540 of the bundle of documents, 2011 ICR reports 1195. It was that a terrible case of the sad demise of a young child under the watch of the then director of Education and Children's Services for Hackney. This case, in my submission, deals with that pointer, because what was raised on behalf of the Secretary of State, the action was brought against both Ofsted and the Secretary of State. The arguments raised on behalf of the Secretary of State was there is the employment tribunal, and therefore the public law aspect of it ought to be dealt with there as well. And the Court of Appeal rejected that in respect of the complaints against the Secretary of State, because, my Lord, you might recall, and my Lady, that there were public outcries, and in fact, on the facts of this case, the director, who's a public office holder, was in effect dismissed in the media. And factually, my submission, that's similar to what's happened in this particular case, where the announcement of suspension was in the media and you had reports being read in the media. It's the old abrogation of the fair process that ought to have taken place leading up to action. And the Secretary of State clearly was not the employer of Ms. Shoesmith, but he had, in similar to Cabinet here, powers to intervene and make various, seek various reports from Ofsted and indeed make suggestions as to her dismissal. So in that context, in my submission, Shoesmith supports the proposition that even if there is a remedy in any event in employment tribunal, the public law element and the remedy that's been sought, certainly in this case, the declaration can proceed in any event in the High Court.
Right.
Yeah, my Lord, I think that would be, wish to go through all the others and say, but the other cases in my submission relied on by the appellants don't assist. Daly just deals with the anxious scrutiny point on judicial review, in essence. Hart was about the ability.
You are going to go through them all.
Sorry?
You are going to go through them all.
No. An upper tribunal, so it doesn't assist. I simply say that.
Yes. Thank you very much indeed. Yes,
My Lord,
yes, Dr. Dowsett.
maybe ready to address on a number of points. On the point raised in the Dumas case, and in fact we responded to it. In fact, we had raised it at paragraph 41 of our submissions, page 46 of the record, page 46, 46.
Thank you.
And we...
Yes, I saw that, yes.
Yes, in fact, we make it clear that it is competent, quoting from the Dumas case, it is competent to seek declaration in relation to issues of public law. Our case that we are putting forward and submitting is that when one looks at the pit and substance of what is here, our argument is that this one is really a private law matter. So that is our response to their submission on the Dumas case.
I mean, is there something wrong with the proceedings if, in fact, they are private law proceedings which the High Court has jurisdiction in respect of? What would be wrong, I suppose, would be that they should have been started by some different process. Is that right? Because they were started clearly as some form of administrative process by a fixed date,
Yes.
writ or whatever.
Yes. And
What the ordinary High Court process would have involved what?
an ordinary claim form,
An ordinary claim form.
as opposed to a fixed date claim.
Yes, but presumably that's, I mean, if you were right on this point, then they would be administrative court proceedings.
No, if
Which wouldn't they be?
No.
Which could be corrected by being converted to ordinary private law proceedings.
yes.
The judge could say that this was to be treated as going on as if it had been started by an ordinary claim form.
That is correct. No.
Yes.
The High Court does have that
Yes.
jurisdiction, and I think it's also stated explicitly in the rules. Yes.
Are fixed date proceedings limited to public law proceedings?
No, fixed date. There are certain kind of proceedings. Fixed date being administrative law proceedings being one of the fixed date claim forms. But for example, claims for possession of land is another example of proceedings that must proceed by fixed date.
Thank you.
Yeah. But there are a number of proceedings that go by fixed date. But then there's what we call...
Fixed date means that there's simply a fixed date
That's right.
for return. Yes.
That's basically what it is. There's a fixed date.
I see. Right.
And also in fixed date proceedings, you're not able to get a default judgment. But in ordinary proceedings, you can get a default judgment, there being no fixed date for the court to consider the matter. Yes. My Lord, the court, during the reply of my learned friend, drew attention to what was stated by the Court of Appeal, I believe in paragraph 71 of its judgment, the Court of Appeal judgment beginning at page 128, and in particular at paragraph 71. Well, there are a couple of points. I will get to paragraph 71, but just going to what was held, and it will manifest itself in the judgment, in particular at paragraph 69. But I don't think the use of these words are accidental. As stated in what was held, the first holding, beginning at the first holding, it begins at page 129 and concludes at page 130. The last sentence of what was held in point 1.
Yes.
If the rule makers wish to require claimant who seeks an administrative order in the nature of a declaration to first obtain leave, the court would have clearly said so. We have no issue with that. But what we are saying is that, in support of our argument, one has to look really at the nature of the claim being brought. And what we say in this particular case, the claim being brought is in the nature of judicial review. That is what we say. As to paragraph 71, the sentence that seems to be agitating the court is the second sentence beginning at line 3
Yes.
of paragraph 71.
Yes. What's the explanation?
For purposes of what I'm going to say, I'm going to assume this is in the form of a general statement. Of course, I can't say definitively, but I'm going to assume it is in the form of a general statement. In any event, if an applicant files an application for judicial review seeking an administrative order for declaration and damages, which was the state of affairs that existed in the court below, the state of affairs in the court below is that the respondent sought only declarations and damages. Then the judge has plenitude of powers on the CPR to treat the application for judicial review as an application which would be consistent with the declarations, administrative order, which was being sought. And what we respectfully say, this refers to a circumstance where a person is saying they're going for judicial review. But when the court examines the matter, because it does not include a claim for mandamus, etc., the court forms the view that this really is not judicial review. It's not a review, a challenge of a decision. There's no challenge to a decision. On a true view of the matter, it is not judicial review. It ought to be treated as a declaration, even though the applicant is calling it judicial review.
Yes.
And this is what we say. It's not what the claimant calls their claim. The court must look at the claim and determine what it really is, whether it be judicial review or in the nature of a declaration. That is what we say. That is, I think, how we ought to view this particular section of the judgment.
The rules seem to require that the claim should be designated by the claimant as falling within one category or another.
Yes,
But do we know what happened here? Because I looked
No,
at the claim form, it doesn't appear.
Different claimants, in terms of how they, what I could say, type up their papers. And it's not a point that the court is going to strike out a claim, but the rules are clear that in your claim form, you should you should state what kind of claim it is, whether it's judicial review or otherwise.
And we don't have that.
Most persons don't do it. They just say, remedies. And this is what happened, in fact, in this case. If you look at the claim form, which is in the first bundle at page 72, the claimant doesn't expressly say this is a claim for declarations. They just get into the reliefs right away.
Yes.
At page 72, where is the fixed date claim form? So the rules type of, more or less stipulates that you should state, and some claimants do, but many, quite frankly, don't. They just present the claim form and they just dive straight into the remedies. And this is what happened. And it's not. I'm not making a criticism. I'm just saying this is the what happens more often than not.
If it had stipulated that it was judicial review, then presumably the court would not have issued it.
I assume so, because the court sees to the fact that leave is required. Yeah. Yes. And that is why we say the court must not just look at what the remedies are, but determine what really is the nature of the claim. Is it really judicial review, or is it really declarations? My Lord, I think I must, because my learned friend did spend some time talking about the employment issue, and I just want to very briefly, my Lord, just very briefly, refer the court to a case that he cites, the McNana case, and I draw the court's attention to page 606 of the record. And I refer the court to it because it's a point of general application. It's, we think, good law. The ready-mix concrete case, the judgment by McNana. And they refer to House of Lords case, Short versus J&W Henderson, which I believe was from Scotland. And they point to various indicators of a master-servant relationship.
Yes.
And they list them A, B, C, and D. And the only point that we will wish to make, my Lord, is this. As stated at letter E, it seems to me that A and D are chiefly relevant in determining whether there is a contract of any kind, between the supposed master and servant, and that they are of little use in determining whether the contract is one of service. And what we say, given that as a matter of statute, it is cabinet that has the power to select the executive secretary by virtue of Section 11 of the Board of Education Act. That is a statutory function solely for cabinet. D, the master's right of suspension of limits by the Interpretation Act. It is only cabinet that has the right to suspend or dismiss. So what we say, given the fact that the Board of Education has none of those rights, there's no contract at all between the Board of Education.
Fine, but we have pointed out several times that this doesn't seem to us really to be something that we can decide.
No,
or to help us decide issues. I know you're both very keen to tell us what your position is.
No, what I'm saying, my Lord, is that We accept.
We
But-
understand you've got a forceful argument or forcefully put argument, but we can't carry it further than that, can we?
Yeah.
Well, as I said, it's just that.
And even if you succeed in establishing that she was not employed by the board, it doesn't follow that she was employed by the cabinet.
Right.
It's a separate question.
Well, my lord.
It's a curious position public officers
No,
can be in.
well,
we're in the same position. to some extent.
With respect, the thing is that the only basis upon which a claim can arise in the industrial court
Yes.
is on the basis that there's a contract of employment
Yes,
somewhere.
but we're not concerned with that. That you may defeat that easily, but that's not the point.
Well, but I appreciate you get a sense that we are in a kind of unique position here.
Yes, that's well put.
I mean, it's the big elephant in the room. That perhaps for understandable reasons, we understand that you would have a little reluctance to make a finding, but it is there.
Yes.
And
people may be, ready-mix concrete's a case about national insurance contributions, and people are sometimes employees for the purposes of one area of the law, but not for another. It's a difficult issue in itself, which isn't for us to decide today.
Well, my Lord, I recognize it's difficult. When it gets here, it's difficult. I appreciate that. But my Lord, that is, I think, what I would want to say. Just 1 minute.
Yes, I dare say. We probably have national insurance.
Just one other comment. My learned friend suggested that in the action of the minister in suspending or whatever he did with respect to the respondent, that he was somehow bound to get a report or input from the Board of Education. We say that is not correct. One looks at the Board of Education Act. The Board of Education Act, which is to be found at page 192 of the record. And that is where it begins, and we move on to section 11, which is found at page 195. And 11.1, there shall be an executive secretary of the board who shall be appointed by the cabinet. There is no provision for the appointment to be subject to the advice or input of the Board of Education. The reason why that is important, because when one looks at the Interpretation Act, which begins at page 210, section 18, it talks about an authority having the power to appoint. It says towards the end of subsection 1, where the power of appointment is only exercisable upon the recommendation or subject to the approval, consent, or concurrence of some other person or authority, the power of removal shall, unless the contrary intention is expressed in the enactment, be exercised only upon the recommendation or subject to the approval, consent, or concurrence of that other person or authority. Yeah. And so in this particular case, it is clearly, it's not a situation where if the minister decides to suspend or remove or whatever, the executive secretary, that he is required to obtain any input or the consent of the Board of Education, of the Board of Education. The law does not mandate such a process. It's solely the cabinet.
Well, again, I mean, we can't go into the facts, but the reality is that certainly as regards the extension of the period of suspension, that was done on the directive of the Ministry of Education, apparently by the Board of Education, which shows that there's a slightly different shows a slightly different perspective, doesn't it? But there we are. We really can't go into the factual position, except insofar as we're analysing what the nature of the claim is and so on, but we can't determine questions which are clearly going to be very contentious.
Well, yeah, well, clearly, there hasn't been a full hearing in terms of determination of what the facts are. We are, as the issues are stated in the statement of facts and issues, what really was before the court. Was it a judicial review or otherwise? We say it was judicial review.
Yes. Well, thank you very much indeed, Dr. Stoutsey.
I think the court made a direction for...
Yes, we ought to give you... how long do you need to make submissions in writing on the Belize case?
My lord, I certainly...
You'll be going elsewhere.
We are leaving right from now to Antigua, straight into the Court of Appeal in Antigua for 1 week. And we will be there morning, noon, and night from...
Unlike here, we're letting you off early.
From Monday to Friday. And so...
Well, I hope this has been a pleasant, relaxing wind-up.
So if we could be afforded, say, until the 2nd of March, 2 weeks after the Court of Appeal.
Well, that's a long way ahead.
I know, but that's why I alerted the court to the 2nd. 2 weeks after the Court of Appeal.
Well, you don't really need 2 weeks to make...
After the court?
No, 2 weeks to make submissions on a fairly short case is, I think, a bit excessive, if I may say so. I don't know what you feel. We certainly give you... where are we now? We're on the 7th. Wait a minute, sorry.
That is the 8th, I think.
The 8th, yeah. So you're in the Court of Appeal next week.
Yes.
Why don't we give you until the end of the week after that, Friday the 23rd?
Very well, my lord.
Is that...
That is very suitable.
Good?
Very suitable, very good. I do not see why my learned friend needs 2 weeks.
No, I think a week.
I was totally
I am in the Court of
exhausted.
Appeal.
You can find it on the internet
Also.
and read it on the plane back to Antigua this evening.
Rather than sleep.
Right. Exchange of... Well, the board's grateful to counsel on both sides for their submissions, and it will take time to consider what advice it will humbly tender to Her Majesty.
Much obliged to the court.
And may we wish you a good return.
Thank you.